Prepared this morning with your sovereign citizen argument? You needed some additional time to prepare?
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those very.
Welcome back, everyone. Today's double feature is one for the courtroom history books. 2 states, 2 defendants, and 1 universal lesson. Judges don't play games with sovereign citizens. First up, we head to Kansas, where a man named Gordon insists he's not a person, just a man. And then we're flying south to Florida, where another self-proclaimed secure party creditor tries to school a judge on the 14th Amendment, only to realize he's completely out of his depth.
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
So have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since you charge this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plead. I guess I'll answer in affirmative if Demers is not acquiesced to quasi.
Right here, you can already see the pattern. The defendant's confusion between person and man is classic sovereign citizen wordplay. They believe that by separating their physical self from their legal fiction, they can somehow opt out of the law. Spoiler, it never works. The judge remains calm, explaining the charges step by step, but you can sense his patience thinning. These individuals walk into court expecting to win on technicalities they read online, and instead they're met with a wall of reality.
If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, If you wish to have a trial by
I'm
jury,
Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
all right.
I-
Mr. Cooley,
Can I ask you a
Mr.
question,
Cooley.
sir?
you need to be quiet for a moment. And I'm going to explain what the situation is. You have the right to be represented by counsel. You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my captor.
And here it is, the signature move. I don't plan to plead. This is where sovereign citizen logic hits a brick wall. The judge immediately enters a not guilty plea on his behalf, which completely derails the defendant's attempt to control the narrative that it's a small but powerful moment. A reminder that courtroom procedure doesn't bend to delusion. The judge doesn't mock him. He just keeps the system moving. It's calm, professional, and devastatingly effective.
I don't understand what a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no
Mr.
claim
Cooley,
has been brought
Mr. Cooley,
against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
At
Judge,
2:30?
I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial and for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please?
you've been-
Can we bring
you've
the
been-
law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law right.
When Gordon starts talking about injured parties and private settlement, he's echoing internet templates used by sovereign citizen groups. They twist real legal terms, like common law or contract, into fantasy defenses. But the judge, experienced and grounded, cuts right through it. This exchange perfectly shows why courtroom knowledge matters. Passion without understanding doesn't win cases, it just gets you booked for contempt.
I'll come to the jail and talk to you.
Morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23-174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, Mark Sims, to represent you in the 24 case.
I go state this to the yes.
Now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen.
And just when you think Kansas gave us enough courtroom chaos, Florida steps in, always ready to up the ante. Judge Collier is next, and his style couldn't be more different. That he's calm, quick, and surgical, the kind of judge who won't let nonsense linger for long. Our new defendant, Mr. Morris, walks in full of confidence, armed with his own handwritten legal theories. What he doesn't realize, he's about to get schooled on constitutional law by someone who actually knows it.
Something about a secured.
My name is Alizé Morris, a secured party creditor under the UCC1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States, not a record. So documentation, which is official records, to state it. I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory
Okay. Tell me what the 14th Amendment says.
that you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This if you commit a crime
Okay. Doesn't say if you commit a crime.
or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What
Right.
book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's
I was
because it's an amendment to the U.S.
Yes.
Constitution.
Mhm.
So you don't know what the 14th Amendment reads.
The 14th Amendment reads not off the top, not off.
This part is both hilarious and painful to watch. The defendant starts quoting the 14th Amendment, or at least trying to, but the moment the judge asks him to explain what it actually says, the illusion collapses. Here's what's fascinating. Sovereign citizens often invoke real constitutional terms like UCC filings or secured party creditors, but they don't understand them. These legal filings exist, but they have zero power to override criminal law. The judge handles it perfectly. He doesn't ridicule, he educates, and that's what makes this scene gold.
That I'm a secured party creditor under the UCC1.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared You're not prepared this morning with your sovereign citizen argument. You needed some additional time to prepare.
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
Judge Collier's sarcasm here is legendary. You need some additional time to prepare your sovereign citizen argument. Translation? Go study the actual law before you embarrass yourself again. And that quick line about giving him 6 years, comedic perfection with a dash of courtroom authority. It's a rare moment where a judge uses humor not just to diffuse tension, but to remind everyone that the court isn't a stage for pseudo-legal theatrics.
He's got 2 cases. I know one we've already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here, what is state?
we're gonna, May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna
sir.
come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk about.
And there you have it. 2 courts, 2 sovereign citizens, and 2 judges who refuse to play along. From Kansas to Florida, one truth rings loud and clear. Confidence without comprehension will always lose in a courtroom. Whether you agree with the system or not, understanding it is the first step to changing it, not defying it. If you found this case as wild and entertaining as we did, hit that like button, share your thoughts down below. Do you think judges should handle these cases with humor or firmness?